Thank you, Mr. Chairman, and thank you to our witnesses for being here. The Supreme Court's decision in Mahmoud v. Taylor was narrow, but the conversation surrounding it has not been. There's a real risk that this ruling is used to blur a longstanding constitutional line between protecting families from compelled belief and undermining the basic function of public education. Public schools do not exist to affirm any one worldview. They exist to prepare students to live in a diverse, pluralistic society. That necessarily includes exposure to ideas that students and families may not agree with. So my questions today are about limits, about guardrails, and about making sure that we do not turn a narrow ruling into a broad mandate that destabilizes classrooms across the country. So let me turn to our witnesses. Mr. Rothschild, the Supreme Court has consistently distinguished between compelled speech or forced affirmation of belief on the one hand, and the ordinary work of public education, including civics education, that exposes students to differing ideas over time. In Mahmoud, did the court meaningfully engage with that distinction? And going forward, how should courts understand the difference between unconstitutional coercion and the slow, non-coercive process of educating students in a democratic society?
That last line of yours, I believe, is from Barnett, cited in 1943 by Justice Jackson, which was considered the quintessential statement on this very distinction that you're raising between your right to send your children to private school and that if your child is to attend a public school, that within public schools there are some limits. So to go back to a question that Mr. Kiley was asking me before, I think there are limits, and Barnett, for example, represents some of them. And lower courts, since 1943, unanimously held to that distinction as well. Mahmoud disrupts it.
Okay, so do you see a risk that Mahmoud could be misinterpreted to treat mere exposure to ideas as constitutionally suspect, even when no student is required to affirm or adopt those ideas?
I think it definitely will be interpreted that way, yes.
While Mahmoud was framed as a narrow ruling, it raises broader questions about who gets to decide what is fundamentally necessary to teach children. So what concerns you about courts or Congress stepping too far into curriculum decisions traditionally made by educators and local communities, and would a federal opt-out law risk replacing professional educational judgment with litigation-driven oversight?
Much better than I can ever articulate this, let me just quote to you Justice Jackson, the author of Barnett, in his concurrence in McCollum in 1948. He said, "If we are to eliminate everything that is objectionable to any of these warring sects or inconsistent with any of their doctrines, we will leave public education in shreds. Nothing but educational confusion and a discrediting of the public school system can result from subjecting it to constant lawsuits." Now, maybe that's the point.
Yeah, maybe so. So in your view, which institutions are best suited to set these boundaries in a way that protects religious liberty without eroding the mission of public education, local school boards, educators, states, or federal lawmakers? Which one of those?
I mean, it has long been recognized that if there's any area where democracy is to reign, it's with respect to local government, and there's nothing perhaps more local than boards of education in educational districts. Again, to quote from Brown v. Board of Education, "Education is perhaps the most important function of state and local governments."
Thank you, sir. I agree. Mr. Chairman, I yield back.